about the pitfalls of failing to adequately protect your intellectual property, which is to say, adequately registering your copyrights for your songs. So your songs, the compositions, as well as the master recordings. So, guys, it was you all, and in particular you, Brent, that kind of instigated this panel topic. So can you talk a little bit about why you felt that it was important for us to address this topic now? Because I think that a lot of us tend to downplay the importance of copyright protection. I think some of us sort of take it for granted that that's all been worked out now. You know, everybody's so thoroughly educated about all of the steps you need to take for protecting your copyright, so it's no longer really an issue. But that's not entirely the case, is it?
No, I think that thinking is fundamentally flawed, which is, I think, maybe why we pressured for this as a discussion. You know, one of the, and we can get into the hows and the whys and the specifics. I don't want to kind of advance the show too much or steal your thunder, but you know, one of the driving factors for me in the importance of this issue was really born by some of the experiences we had with our artists, right? So I'm CEO of a couple of music technology companies. The original one being AudioSocket. So we've got about 70,000 copyrights in our roster. Comes from emerging bands.
Explain what AudioSocket does.
Yeah, so AudioSocket is a music licensing technology company that represents independent artists and independent labels in an effort to secure sync placements for their content in film, TV, commercials, video games, any kind of media. The artists own their copyrights. They're just providing us the right to represent them and try to secure sync placements and therefore revenue for their intellectual property. And there's a platform, anybody in the world can go to audiosocket.com and say, I want an indie rock song with female vocals, medium tempo, and a flute, and if all those criteria match, then you get results just like you would in Google, but you can listen to the music and you can license it from the site for pretty limited commercial rights, or you can interact with one of our sales reps to do more broader commercial placements for television. And in the volume of business that we do, and we issue thousands of licenses a month, it was shocking to me. This is not formulated scientifically, but my guess is probably 98% of our artists have never formally filed copyrights, and they have no idea.
And these are artists that you're already representing.
Yeah, I mean,
who have signed paperwork saying that they.
Well, they own the copyright inherently, and the lawyer's here, so he can slap me anytime I say something wrong. I fully expect that.
Actually, just go ahead and slap him right now, would you?
Maybe later. So I mean, there's inherent rights that you have upon the completion of a created work, right? But that doesn't mean that all the protections are in place, and they're not in place until you formally file. And I don't think most artists realize that, and more importantly, they don't realize how much it limits them when things go wrong. And we can get into some specific examples of where things went wrong, and it cost our artists 6 figures to not have filed correctly.
Wait, say that again?
It cost our artists 6 figures to not have filed correctly.
Because of licensing fees that they're not able to collect.
There's something called statutory damages that a copyright holder is entitled to in federal court if somebody violates their copyright. But there are a couple of things that you need to do in order to have access to statutory damages. One is you need to have formally and properly filed your copyright with the Copyright Office prior to the infringement happening. And secondly, you need to have exclusive representation over your work. And if those 2 things are not met, there's still damages available to you, contractual damages, lost licensing fees. But statutory damages are an incredible hammer. And when a defendant, somebody who has potentially violated your copyright, is essentially facing legal dispute and litigation over the misuse of your work, their willingness to negotiate on a fair compensation for their abuse of your copyright is greatly increased when they know that the judge potentially is going to demand that they pay you statutory damages, which are $150,000 per infringement.
So Tim, let's review real quick. At what point in the creative process does the composer or author of a work own their copyright?
Right. So under copyright law, the moment that you fix any work of authorship in a tangible medium of expression is when the copyright vests. And the copyright vests with the author of the work. Right?
So if I sing a tune out into the air right now and say, I wrote that, I own it, am I owning my copyright?
No, but if you record it, then yes. I mean, if it's copyrightable subject matter, and
So if I like record it onto my telephone, does that count?
Yeah, I mean, any tangible medium of expression, and that's a technical way of saying something that could be reproduced.
What we used to call it fixed tangible form.
Yeah.
So paper,
anything
plastic,
that can be reproduced,
flash drive, cassette tape, anything like that. Mm-hmm. Okay, but
Yeah.
and if I write a poem or a song and I put it on paper, and now I own it, and you use it in a TV commercial, I can sue you, right?
Well, yeah, that's right. I mean, but you have to, your ticket into court is a copyright registration.
The registration.
You have to have yes, you own the copyright from the moment you fix it. But the easiest way to think about this is that we used to be a jurisdiction, the United States used to be a jurisdiction that required copyright registration in order to obtain rights. So it used to be that this whole, vesting of rights upon fixation was not the case. You didn't get your rights until you registered with the Copyright Office. But toward the middle of last century, we had some treaty obligations, some international treaty obligations that we had to comply with. And so the U.S. had to do away with what were called copyright formalities, basically things that were standing in the way of you and your ownership. So, for example, they did away with the requirement that you register your copyright. It also used to be the case that if you put your copyright, if you put your work out into the public without the proper copyright notice, in other words, copyright 2017, you could lose your copyright. So those were the sorts of formalities that we had to get rid of in order to comply with treaty obligations. But we did so sort of kicking and screaming. So all those copyright formalities, we didn't really want to let go of. So what they did is they made them, yes, you get your rights upon vesting, but you can't enforce your rights unless you have registered your copyright. You cannot, we talked about statutory damages. A lot of people think that just registering your copyright prior to the infringement occurring will, you can avail yourself of statutory damages. It has to be within 3 months of publication. So if you put your work out, on SoundCloud, and it's out there for 3 months, if you haven't registered your copyright, you don't get statutory damages.
So I own the copyright in my work, not at the moment that I write it or that I create it, not at the moment that I think it,
right? Not ideas,
but at the moment that I fix it into some sort of fixed tangible form. That is when I formally own my copyright. But if I write a song and record a song and put it up on SoundCloud, and 3 months and 1 day go by, and Pepsi decides to use it for a commercial,
you can register your copyright at that point, or you can. And sometimes they actually have a process called pre-registration. But that's you can register your copyright and then go after Pepsi. But what you're going to be limited to is proving actual damages, and actual damages are a problem for 2 reasons, and they're related. One, you may not have any actual damages, right? It's hard. Sometimes it's difficult to prove what damages resulted from somebody, posting your copyright on YouTube, right, or posting your song on YouTube. It's hard to quantify that. The second part is that courts, the calculation of actual damages is an area where courts rely on and practically require expert testimony to come in and figure out how much were you harmed, right? There's got to be an expert that comes in and testifies for the court, and those experts are they're probably more expensive than your lawyer. I mean, they can be $250, $500 an hour, and so
wait, you don't charge that much?
Well, I'm at the low, maybe. I'm in between those.
At these prices?
Yeah. So the problem is that you can get empty victories, right? So you can go out and get injunctive relief, right? Injunctive relief meaning stop doing what you are doing. But in terms of collecting damages, if you don't have the Congress knew that it was really difficult to quantify actual damages. That's why they put statutory damages in place. So, but they don't allow you to take those statutory damages unless you register your copyright. And not only must you register it, but it has to be registered within 3 months of you putting it out.
All right, well, let's get into a real-world example of all this, because it seems like I would imagine that for a lot of us, talking about the ability to claim statutory damages and talking about actual damages and things like that, and whether or not I've actually protected my copyright, I think for a lot of you said that there are still tons and tons of artists that are on your platform who haven't even taken the step of formally registering their copyrights.
Yeah, the 98% is my estimate.
98% of your,
and we've got a couple thousand artists, right?
Okay.
So yeah, we're here today to make it obvious for you, and hopefully it inspires you to, if you are a musician and you've got copyrighted works, to go home and.
So one of the artists that is on the AudioSocket platform has a song, and that song ended up being used in a rather blatant way. And I think we have a clip of the usage of this song. So do you want to set up what we're going to talk about?
So you got the video from Travis, right? Okay. Right, exactly. So let me just let's set this up just a little bit. I won't be too long-winded, but so you know what AudioSocket is, music licensing technology company. The world comes to us and they grab licenses for use in commercial video. And unfortunately, as we've gotten broader distribution, in other words, more people coming to us to license, we, a couple of years ago, realized that people were stealing our shit almost as much as they were paying us for it. And I went to my technology team and I said, guys, 2 questions. One, can we solve for this? Technologically, is there a way for us to track these copyrights at scale and protect them? And then the second question is, if we can do it, do we have enough bandwidth, manpower, resources to get it done? And in short, they figured it out. So they created a technology system that we call License ID. And what License ID does is every time a file leaves the AudioSocket system, it encodes inaudible data, so inaudible watermarking, into that media file to list everything we know about that delivery, where it was going and why, at the time we sent it. So if Jane Doe at Gray Advertising licensed this song on behalf of Nike for 1 year use on the web, all of that rights information is in the audio file itself. It's impossible to hear. It's impossible to get rid of as well. And then we're pulling in television feeds from hundreds of national broadcasters. We're crawling the web, YouTube, Facebook, Vimeo, other sites, and we find these copyrighted uses in work. And there was a presidential campaign recently. I don't know if y'all remember that tragedy. But when it was kind of the final weeks leading up to the primary.
You mean the one in France, right?
No, this is here in the U.S. I've tried to block it out, but I still recall some things. But it was kind of Ted Cruz and Trump are the last two standing. And the Cruz campaign, specifically their agency, we noticed that they had downloaded a track from a set of our artists, but specifically Sarah Schachner, who we're going to be introducing here in a second. And one of my reps called the agent and said, hey, I see y'all do a lot of political work. I want you to know that we do not license for political purposes, ever. It's just, pornography and politics, we stay away from it, right? So, and they said, okay, yeah, no worries. We really like this song, but if the artist isn't down, then we won't use it. We'll just hire a composer. And we said, okay, cool, good luck. If we can help in any other way, please let us know. And in the license ID technology, again, we crawl the web, we scan TV. After we told them not to use it, specifically, after they told us, oh, got it, no problem, we'll hire a composer, our technology picked up in broadcast television that the Cruz campaign had a commercial with Sarah Schachner's song in it, and we can show the video.
So this is after they asked, can we use it?
And after we told them no.
So they didn't take no for an answer.
You ever imagine a politician doing something criminal and corrupt?
Too bad you didn't approve the use of the song.
I still get a little sick every time I see it. Yeah, anyway, so Sarah Schachner is a composer on our roster. She's quite prolific. She's an amazing songwriter. She has a ton of great songs that she's written. She probably one of our more licensed artists in the roster, and as sophisticated as Sarah is, and she is. She's an incredibly smart, incredibly talented woman. She never filed copyright on that song.
She never did.
She never did. So, you know, we spun the license ID product out into a separate business called LidCore. So we have two companies here, and LidCore essentially acts to protect and monitor AudioSocket's copyrights. And we know a thing or two about this, and no offense to attorneys, but unfortunately we have way too many around us. The legal bills are through the roof. So we went to our attorney and we said, look, this thing aired on Fox Television nationally more than 86 times. It's all over YouTube and the web and Vimeo. It's getting tens of thousands of views and likes and comments. What are we going to do? So there's good news for us because we knew that most of our artists have not filed copyrights. All of our contracts, as well as the terms of use on the AudioSocket website, list what are called liquidated damages, which essentially is, and you can explain this in better legal terms, but in my perspective, it's essentially the company claiming in advance, if you screw up and you mess with our stuff, here's what we think is a fair and reasonable loss to the company and its reputations with its artist, and actual damages kind of predefined in advance. So we had that working for us, the liquidated damages in the contract itself, and the agency did come back and bought like a $2 personal license, so there was some contractual obligation they already engaged in through that transaction. So our lawyers got incredibly excited about this case because it was at the end of a political campaign. It was hotly contested between Trump and Cruz. And we first went and we filed the copyright because you can't bring, to Tim's previous point, you can't bring a complaint in court without that. Now,
so the song has already been written and recorded and released. It's being used without permission in a nationally broadcast political commercial.
right.
And yet the artist has not actually registered the copyright of the song or the master recording with the Copyright Office. So everybody here knows how to properly register the copyright to a song and a recording, right? You put it in an envelope, you put a stamp on the envelope, and you mail it to yourself, and you don't own it. That's a legal copyright. Yeah.
No, so the poor man's copyright is probably one of the most frustrating things that I deal with. When I'm dealing with clients who have never registered their copyrights before. So there's this notion, and I've heard it described to me a number of different ways, but people think that because the post office is some sort of federal agency, that if they mail themselves a copy of their work, that establishes, but you can never open the envelope after
because
if
you've written
the
do
seal
not
is
open
broken,
until Christmas.
right? If the seal is broken, there's no poor man's copyright, right? So they have these theories, and it's I don't know where it got started, but it's totally
Fake news.
It's total fake news, right? Because you cannot get into court. If you try to walk into court and enforce your copyright and you do not have a registration, they will tell you to leave. And so this whole idea of poor man's copyright, I don't know who is pushing this. Perhaps it's the Postal Service. I don't know. but it's a total fallacy. And if anybody ever tells you, yeah, well, I got my poor man's copyright, that's you wasted.
That's when you
stamp.
smack them, right?
Yeah, you hit them. Yes. No, but it's a waste.
You still
of a
haven't
stamp.
smacked Brent, by the way. I'm still waiting.
I
for
know.
that.
I can't.
screwed
It's his
up yet.
birthday. I'm
I
not going to
have not
smack
yet.
him on his birthday.
Okay, so a real copyright registration is
It has to go through the Copyright Office, and they've now it's so easy now because they've digitized the whole process. So you can register both the sound recording and the musical composition, and generally it's important to register both. That was actually an issue in the Marvin Gaye case, was that they did not have the sound recording they could not sue on the sound recording. They were only suing on the musical composition copyright.
That was on the Robin Thicke?
On the Robin Thicke, Pharrell, Marvin Gaye case. But in any event, it's important to register both.
Sound recording is the master recording.
Sound recording is the fixation. There can be many different versions of a recording, but there's only one song, right? So the musical composition doesn't change. But there could be multiple sound recordings.
That's the performing artwork copyright, the PA, right?
Right. The form PA is what you use for a musical composition, and the form SR is the form that you use to register your sound recording. Now, the registration cost is pretty minimal. It's about $35, and if they've made it easy for musicians that you can actually register both your compositions and your sound recordings on a Form SR, and you can do multiple of them. You can do as many as you want, as long as the authorship is the same between both of them, right? So if you're the only writer of the composition and you're also the only author of the sound recording, then you can do both at the same time. If there's different authorship, then you have to file a PA and you have to file an SR. But it's still only $35 to do that. For each registration. So that's how it works. You go to copyright.gov, and they've made it really easy. And then you have to submit a copy of it. Ordinarily, we just upload a sound recording, and that's an easy process as well. You can also send in a CD, but they prefer that you not do that. They just want you to upload a copy. So at that point, it usually takes about, I'd say, 6 to 9 months from the time that you put in your registration. You can expedite it for about, I don't know, $700.
Not worth it.
Yeah. I mean, unless you're trying to sue, right? In that point, then expedite
Which
it.
you were doing.
Yeah, but you have the protection from the day of filing, not from the day that they essentially approve.
In most jurisdictions, yes. There's a circuit split on that, but in most jurisdictions they say that it is the date of filing, not the date that you are actually granted the registration. That's
all
right.
right. So let's get back to the litigation against Cruz. So you realize that the artist has not properly registered the copyright. So you go ahead and you didn't expedite, but you registered with the Copyright Office. Then what happened?
So we want to get in federal court, right, up in King County, Washington, which is where part of our company is at, and certainly our attorneys are. So we filed the copyright on behalf of the artist, and there was 3 different artists that Ted Cruz's agency violated. We just highlight Sarah as kind of the most obvious because it broadcast on television as well. So we filed all 3 of the copyrights for all 3 of those songs that were violated, and then we instantly drafted the complaint and filed it in federal court up in King County, so essentially Seattle, Washington. And the Cruz campaign and their agency, they all received notice as well. And again, the artist had not filed copyright in advance, so there was no statutory damages available to us or the artist directly, because while the copyright was filed now, and we could reasonably get into court to have the case heard, there's no going backwards. It wasn't filed at the time of infringement. It wasn't filed 3 months after initial release.
So you got a $2 license, but no damages.
Exactly. And the hammer.
That sucks.
It could have. Yeah. I mean, luckily, we've structured our business fair enough to mitigate some of these risks. So with the liquidated damages in AudioSocket's agreements being so clear and plain, obviously, we had something that we could hold up in front of the court and say, Your Honor, this was something that was written in the agreement. We told them not to use the song. They purchased a $2 personal license from the website. The license clearly states all the restrictions, including no political campaigns, and the liquidated damages. So, the Cruz campaign, they're not slouches. He himself is an attorney, and obviously I don't think money was much of an issue for them. They did pretty well on the fundraising for their presidential bid. So they filed an early motion to dismiss. Basically, they told the court, we think these AudioSocket guys are a bunch of clowns.
Clearly.
We don't, well, of course, I mean, I am the leader. So, we don't believe that there's any evidence here. And the statement of liquidated damages is not fair and reasonable. So we had to respond to that motion to dismiss. And I don't know how much they spent on the draft, but I'm assuming it was somewhere between 10 and 20 grand. And these guys are not cheap, right? So we had to spend more money writing our own response to get the judge to essentially refuse that order. And the judge studied it And luckily for us, he came back with 2 clear opinions. One was on the evidence side that the license ID technology, the watermark that was in there, the judge said was quote unquote proof in and of itself of liability. And then secondly, he looked at the liquidated damages and he said these, at first blush, meet the court's demands of being both fair and reasonable. And the Cruz campaign was really freaked out, I guess you could say, because they were looking at the 82 broadcast of Sarah's tracks on Fox, national channel, and they were in their own head. We didn't tell them this. They were multiplying the $25,000 liquidated damages times 82 infringements plus the web infringements. And if you looked at it on a per view basis, it got into the billions pretty quickly. So they were
more than $2.
More than $2, but still, statutory damage is not available because no copyright. So when the judge refused their motion to dismiss, they moved to settlement a couple weeks later, and we closed that through mediation in the federal courts. And we arrived at, I think, what are fair and reasonable terms. It was still sub 6 figures, but it was certainly right in line with what the contracts demanded in the liquidated damages areas, given the amount of uses. And I think equally important for everybody in the room who's an artist, as well as for AudioSocket and Lidcore, the Cruz campaign and their agency wrote us a public apology acknowledging the importance of copyrights and protection and holding up the virtues of technologies like license ID and their importance in bringing transparency and trackability to the misuse of artists' work. So all in all, a win. I think in my personal estimate, we went after the right bad guys, and it felt incredibly.
So they ended up paying.
They did, yeah, immediately.
And the artist Sarah, she got a chunk of that.
The artist got compensated, and the lawyers got compensated.
So what would be interesting is what would have happened if that hadn't gone through AudioSocket. There wasn't that liquidated damage provision, which your description is absolutely correct. It's just a pre-agreed amount, a contractual obligation where 2 parties agree that, hey, if you breach this, my actual damages are going to be $25,000.
Well, if her song was not part of AudioSocket's platform and had the watermarking technology, you never would have known that it was being used.
Well, it could have. Perhaps. So let's just say that
unless she was watching Fox News all day.
So it's all she sees that it's on Fox, right? She comes to my office and she says, I got a problem. This song, they took my song and they used it without permission. And I want to file a copyright infringement lawsuit. And I get excited. I'm saying, all right, okay, well, do you have a copyright registration? And she says, no. I say, okay.
So there's nothing you can't help. There's nothing you can do.
Can you afford my hourly rates? No, you can't. Well, then we're out of luck, because I'll take something on contingency if there's the opportunity for statutory damages, meaning that I'm not going to charge my hourly rate. I'm just going to litigate this, and if we're successful, I'll take a percentage of what we get. But for most people, if there's no statutory damages available, I have no choice but to, bill hourly like lawyers bill.
Or pass on the case.
On the case. And so that's the importance of, it's not just a matter of, I can't get in the court. You're not going to be able to find a lawyer, because unless you can afford hourly rates, nobody's going to take it on contingency unless you have the availability of statutory damage.
So let's bring it back to where we are. So here's an artist. I'm sorry, tell me her name again.
Her name is Sarah Schechter.
Okay, so clearly a household name.
I mean, she's an independent composer.
Right. What I mean is, she's not anybody who's super famous. She sounds like U2, but it's clearly not U2.
Right, exactly.
So, in fact, she's such a indie artist, she forgot to file the registration for her copyright. And still...
Marvin Gaye also forgot to file his...
Yeah, okay. But let's, we're not talking about Marvin Gaye level right now. So, like many an independent artist, she neglected to file the registration paperwork for the copyright for her song. She was fortunate enough to be associated with you guys, and you were able to nail the perpetrator in this case for a settlement, an out-of-court settlement that you said was less than 6 figures. So less than...
And again, there was 3 infringements, so it had all 3 artists, and it's not Sarah. We're having this panel today because most people do exactly what Sarah and the other 2 artists had done. They don't
or neglected to do.
They don't quite think through the importance of formal copyright filing. And my goal is to just shine a light on the subject and create improvements. But had all 3 of them done that, the Cruz campaign and their agency would have been looking at $500,000 essentially guaranteed in statutory damage.
At least, yeah, because some courts will say, I mean, there were 3 rights that were violated. Copyright is not a single right. It's about 6 individual rights that get put together into one. And so they were violating the distribution right, the reproduction right, and the public performance right. Exactly. And so some courts will say each one of those is an individual claim. So willful damages, 150. So you're looking at
$100,000 per times 3. So that's $1.5 million is what we would have had a more easy opportunity in accessing had all the formal filings been done. So if anything, like you take away anything from this discussion today, it's in not doing this in a single infringement, you could cost yourself $500,000.
So this is the point that I want to underscore. So an independent artist that, forgive me for saying this, I've never heard of, let's say nobody's ever heard of except for her, her diehard fan base. Her song gets picked up some kind of way by a national advertiser, in this case a political campaign, but it gets broadcast on national TV multiple times. If she had gone the route of properly registering the copyright on this song that was just this indie release that she's selling from the bandstand, right? Like everybody here, if she had done that, she would have been able to collect $500,000 per infringement. So 3 infringements, $1.5 million she would have been owed by the Cruz campaign?
No, it's 150,000 times 3 because it's the distribution rights, the performance right, and then the actual.
Okay, 450,000.
150 times 3 is
450.
Yeah.
Yes. So not the 1.5 million I said.
Bloody Mary's an early morning. I don't do math.
Yeah, I mean $500,000 is still a good amount of money,
Yeah, it's a ton of money. I don't care how much money you make. I mean,
that's one good record sale right there.
Absolutely.
You don't have to sell 1 million records. You just have to sell one for 500,000.
Somebody with deep pockets to infringe your song. That's it.
And I mean, I think we are hammering home the point and the importance of formally filing your copyright in advance of release, right? But to crystallize the size and the scale of this problem, the Ted Cruz and the agency that represented him, that's the only litigation we've done. But the license ID platform for AudioSocket alone identifies about $30,000 or $40,000 a week in unlicensed uses. Okay, a week.
And these are all independent artists,
none of which have filed their copyright.
So our point is that copyright infringement and unauthorized uses of your music isn't something that only occurs with the Marvin Gayes of the world and the Beyoncés of the world and the Pharrells of the world and all that stuff. It happens to plain old, everyday, average artists that 99% of the world has never heard of.
Yeah, I mean, it's rampant. And we could kind of navel gaze on why, but in our experience, and again, there's so many of these that we see every single day and that we pursue through the LidCore platform on AudioSocket's behalf. And if you thin slice a good bit of this, what I've noticed is that some of the underlying contributing factors are, there's a case that we're getting ready to have to litigate now because they did not respond. This is a global publication, one that you have read before, I can assure you. I won't name them yet. We'll let that come out publicly. They violated...
You mean the National Enquirer?
Much bigger. They violated 86 copyrights of AudioSockets, and unfortunately, my estimate is that they hired some internal video producers who were, I don't know exactly how old they are, but they're probably younger than me. Today's my birthday. I'm 44. They're not anywhere near my age. And unfortunately, a lot of folks have grown up from like a very young age. The music's free, man. I mean, they never had a physical medium like experience of purchase, right? I mean, some kids were born in the days of Napster, right? And unfortunately, as some of these folks have moved into the workforce, they're producing video content for these major publications and these broadcasters, and they're going, oh, this AudioSocket site has great emerging music. I'll buy the $2 license and put it in. You know, hey, at least I paid them something. Never going to find out. Or I'll just download it and throw it in there. They'll never find out. They don't realize that we're sophisticated technologists.
And just to put that in perspective, that little $2 license that you're talking about, that's something that you created for your average Joe Blow that wants to put up on YouTube, you know, his beach vacation home movies of him and his buds at Pensacola, and he wants to put some music behind it, and this is just to allow him to use that music legally, as opposed to, you know, just stealing it. So a little $2 license, anybody can afford that. It's not intended for Coca-Cola or Ted Cruz.
And the document that you get when you buy the $2 personal license says things such as, you cannot use this in anything that in any way derives financial benefit to you or another company. You cannot use this in anything that's broadcast anywhere other than the web. You cannot use this in a political campaign. You cannot use this for commercial purposes. You, Scott, can use it in the video that you made of Ben skateboarding down the Bywater. And that's it. Put it up on YouTube, have fun. You were trying to make it available for
Have you been watching my Instagram?
Oh, I watch all kinds of stuff, Scott.
All right, so I have a question. How many of you here are recording artists? Show of hands. Okay. How many of you have filed the registration paperwork with the Library of Congress, the Office of Copyright of the United States, to register the copyrights of your recorded music? That's not nearly half as many hands that just went up.
I'm still shocked that we had a 50% or close, even a 40% take on that. That's
so a handful of you have done it, but the rest of you are on notice that you have all just cost yourselves $450,000 in missed opportunities because Ted Cruz is looking for your music right now.
Are we liable for things like that?
That was scientific.
Absolutely. I mean, I think there's, you know, when we're focusing on independent musicians, when we were getting ready for this panel, you know, we were talking about how little money gets made through things like YouTube, right? When you're putting your music up on YouTube, and frankly, you know, on Spotify and those other sorts of platforms. That, Brent, you're right. I mean, our consumption model has just changed, right? And there's a lot of people who view other people's copyrights as a barrier to their own innovation. They view them, you know, as some sort of wall that has to be scaled or just, you know, broken through.
Wait, what? They view copyrights as a barrier to their innovation?
They do. I mean, a lot of they look at people. They have this great idea.
They get writer's block at the thought of having to file their copyrights?
Oh, no. So they have somebody has a great idea for a music tech company, right? So some sort of technology company that utilizes music in some form or fashion. The problem is that they have no way to license that music, right? Because they don't have the money or they don't have the contacts. So they say, look, what we'll do is we'll just put this thing out here, right? We'll just use these copyrights and we'll ask for forgiveness later. Because if we don't do it this way, then we're never going to get to launch our product. And so and what I'm saying is not that we as creators view, our musical creators view copyright as a barrier to innovation. But many in the tech industry do. They look at intellectual property as something that has to be, you know, it's just kind of a nuisance.
You mean if they want to use your intellectual property?
Yeah, if
they don't have time.
Well, they can't be bothered to
like Ted Cruz, they couldn't be bothered to.
Or like Netflix, like Napster. Napster wanted to make the entire universe of music available for file sharing and exchange, but that pesky thing about having to actually compensate the people who work their asses off all their life to get good enough to write a song, they were in the fucking way. So what did they do? They just launched Napster and, you know, figured they'd ask for forgiveness later.
Yeah, well, look at them now.
Well,
yeah,
I mean,
but it worked for YouTube, right? YouTube did the same
absolutely.
thing.
YouTube.
All right, so talk about the YouTube thing because you brought up YouTube and you brought up we have a few minutes left. And by the way, if anybody has any questions, just please go ahead and line up at the microphone, and we will get to them. But you brought up YouTube and you brought up Spotify.
Yeah. So
the reason people aren't making money off of Spotify is totally different from the reason they're not making money off of the YouTube.
That's absolutely true.
So just focus on the YouTube.
All right. So the reason people aren't making any money off of YouTube is a thing called the DMCA. Okay. The DMCA is a part of the U.S. Copyright Act. It was adopted in 1998 before YouTube was even a flicker in anyone's eyes. Okay, and the purpose of the DMCA was to allow growth on the internet and allow people to develop, platforms where individual users could come and engage and act. And so what the DMCA said is, we're not going to hold you, the internet service provider, or the site owners, liable for infringing content that appears on your site, so long as you do X, Y, and Z. And the X, Y, and Z is basically the notice and takedown procedures, right? So where if I find my content on your site, I notify you, you take it down, you give the user, whoever put it up there, an opportunity to counter notice, to say, oh no, I was actually licensed to do this or free to do it. And so that's the way that the DMCA was designed to work, right? But when you have large-scale infringements, you're talking about thousands and thousands of torrents, right? Or hundreds and thousands of videos on YouTube that are unlicensed. The problem is that tracking down you have to send an individual URL, right, to them and say,
to YouTube.
To YouTube, right.
Saying, please take this down.
You can't just say, hey, here's my song Formation. Anytime you see it on anybody's videos other than this one, which is the official, just take it down, okay, because it's not licensed. That's not the way it works. And so what happens is, because the creators end up playing whack-a-mole, on these infringing sites, YouTube was able to say, look, all right, obviously the DMCA is not working for you. Why don't we do this? Why don't we let you monetize it? Why don't we let you monetize your content? And so instead of
they're going to put up an ad against it and give you a share of the revenue.
They're going to put up an ad against it. And so what ends up happening is that YouTube pays about 1/7 of what Spotify pays, and Spotify doesn't pay all that much. I mean, we could talk about that, but YouTube pays even less because it's not a fair negotiation. They have the DMCA protection.
So YouTube says that they don't have the technology to identify.
Oh, that's absolutely not true.
They can know when it's a legitimate Beyonce video, but everybody else who's put up that song on their own personal little videos, they don't have the technology to find that.
Well, the technology is absolutely there. Sometimes what they talk about is that the technology that they have doesn't account for fair use, right? So there are some things like the Prince dancing baby case that got so much play. There are some uses of another person's copyright which are fair under the Copyright Act. It has a lot to do with First Amendment, comment, critique, criticism, educational purposes, et cetera, et cetera. And so, yes, there can be some unlicensed uses that are legitimate through fair use laws. But that is, so they say, well, our technology can identify where a song is, but we can't identify if that's maybe a fair use. We don't have that ability, so we're not going to do it.
How much pornography is there on YouTube?
Oh, there's a lot.
It's disingenuous.
No, there's none.
There's
none.
No, what? Yeah.
So which means they can absolutely find it if they want to.
Yeah, and the paid content that's behind the YouTube Red paywall. Do you ever see that get out there? No, because they are capable of take down, stay down. They just don't do it for artists.
All right,
because they're unfair.
Let's let our audience ask a question.
How y'all doing today? My name is Kevin Penn. I'm a hip hop artist. My question is, if a music producer samples music without consulting with the original creator, is the new song that he created now owned by the creator since he didn't get the proper licensing?
There are two requirements for under the Copyright Act in order for copyright to vest. It has to be what's called independently created and minimally creative. Right, those are the two requirements. And independently created doesn't mean that you created it without the assistance of anyone else. It means that you didn't copy it. So what you have there is if somebody samples your work, they do not have copyright protection in that work. It is simply an infringing work. Copyright never vests because it's violating the rule number 1 of copyright law, which is it can't be copied. So if you don't have permission to copy it, they don't have a valid copyright in the first place. It's just an infringing work.
Okay, thank you.
Next question. Thank you.
This might be a question more for Brent. Just around the back-end side of an audio file, because a lot of times when I'm reading about optimizing assets that I'm developing as a musician, a lot of what the web is optimized for is text, and I'm very curious about how the web indexes audio assets for trackability, like you were talking about, but also discoverability. So there's just like a lot of, I guess, things that I feel are swimming around. So you mentioned the license ID, you mentioned watermark. There's a number that you get once you copyright your work. It's some number that you get from ASCAP or CSAC. And then there's also, when you're uploading to certain websites, you're kind of tagging the genres and certain affiliations that might help the track move a little bit. So that's kind of like one section of the question, if you can help me kind of sort that out. The other part of it is, at which level of the production does that actually happen? Is that at the master stage? Is that when you're actually uploading it to the website that you're kind of putting in these tracking pixels or watermarks or IDs?
Yeah, I'll try not to get too into the...
All right, we only have 5 minutes left in this panel. So
I guess the shortest way to answer your question and be holistic, on the delivery of the file, so when it leaves AudioSocket system and goes to an ad agency or goes to a filmmaker, that's when we apply the watermark, because we know who it is that's downloading it. We've got their email address, if they've actually purchased a license from the site, and we can encode all the rights information as well. So that's when the mark happens, on a unique basis at the time it's delivered. As it relates to using metadata to kind of lift the identification of your content in general, for the marketing side of AudioSocket, we've got 70,000 copyrights that come from about 2,000 plus artists. We've actually split the site into over 2,000 pages that you can't personally see or search for in the site itself, but we've indexed each and every artist and all of their tracks individually, which gives YouTube a hell of a lot more web crawlers when they're actually looking at pages and finding for relevance all the tags for the song, the artist name, the track name, the metadata around kind of search discovery elements. All of that is there, which gives AudioSocket, and we come up in the first page of search results organically for the word music licensing, and it's for those kind of strategies. So,
okay, great. We have another question.
How y'all doing? Blake Owens. I'm a hip hop artist. A lot of the music I like to use, I like to listen to a lot of old school stuff. A lot of the samples and stuff really get me going, but I've been trying to veer away from that, you know, for copyright reasons. A lot of times I come into situations where I'm trying to figure out if I'm crossing the line or not, as far as like a melody of a song, or the words may be similar, but it may not match the actual melody of the original song, and I kind of get caught up. Sometimes I talk to people and they talk about, oh, well, it has to be this many seconds long or this, and I always wondered, you know, is there some type of database or some type of something where I can, you know, determine if a work I create infringes, if it does, you know.
Well, you just identified my second biggest frustration in copyright law, which is this notion that there's a magic number of seconds that you can use before it becomes an infringement. I hear, you know, 3, I hear 1.5, I hear all these different things.
Is that like the 10-second rule when you drop a piece of spaghetti on the floor?
It's exactly like that.
As well as the beat too, as well on a production level too.
I mean, there's a long answer to that, and I'm happy to talk with you about it after the panel, but there is no bright line test. I mean, when you're talking about copyright infringement, it has to be actionable copying, and to be actionable copying, the two parts of the work have to be substantially similar. Substantially similar is a legally defined term, and there's, you know, lots of case law that's arguing about whether two works are substantially similar or not. But no, there's no easy way to determine where that line is. You find out where that line is when you cross it, and somebody says you crossed it. Right. So the easiest thing to do is
I'll know it when I see it. In other words.
Yeah, yeah. So I mean, the easiest thing to do is to try and stay away from sampling altogether. And if you do, what sounds like what you're doing is replays or interpolations, and that's okay. Just make sure it's not too similar, right? So, there's more to that answer, and if you want to see me afterwards, I can talk to you.
Don't sample somebody else's record, and don't take somebody else's tune.
It's pretty simple, but unfortunately, people get I get it. There's a hell of a lot of creativity that goes on in sampling, and groups like that I was growing up, like the Beastie Boys, proved that very very well. Sublime did that very well.
Yeah, but they also clear their samples. And
no, they didn't.
No, oh,
no, they didn't.
Well, after then they got busted.
They did. Yeah,
yeah.
Afterwards
Okay.
they did.
All right. Well, so then they paid the price.
They did. They did.
That's my. Yes, we have one more question.
Hi, Deborah Evans. I'm a music publisher in New Orleans, and I have just a short comment. Tim can back me up on this. But when you register your publishing copyright for the PA with the Copyright Office, make sure you include your publishing company name with it too, because you want your song copyright is divided 50% writer share and 50% publisher share. And this is my one pet peeve, is a lot of songwriters come to me and they're not understanding that their song is divided half and half, 50% writer and 50% publisher. You actually own a publishing company. When you register your song with ASCAP and BMI, you're registering both shares. So on the Copyright Office registration, you want to include your publishing company name as well.
All right. Well, thank you for that. All right. Well, guys, I am so sorry, but we are an hour into it, which means we're out of time. So could we have a round of applause for Tim Kappel and Brent McCrossen, two longtime veterans of the Sync Up Conference. So again, register your copyright, register your copyright, register your copyright, because if you don't, you just gave up $450,000 that Ted Cruz owes you. There
you go.
All right. Hey, we'll be right back with Tank and the Bangers.